The nominating bodies for the lay members represent the consumer, academia and the protection of civil, legal and human rights aspects of the authority's remit. In terms of the non-lay members of the authority, I have borne in mind the fact that there are significantly more solicitors than barristers in the state, a factor of 5 to 1. Firstly, I have removed my ministerial entitlement to nominate a member of the authority. Then, rather than simply increase the number of nominees from the Law Society, I have chosen to designate the Legal Aid Board as an additional nominating body and to require it to nominate a solicitor. In addition, I have reduced the Bar Council's nominees from 2 to 1, but I have given the Honourable Society of King's Inns a nominee as a counterbalance following representations from that body. The proposed new subsections 5 and 6 are an attempt to ensure gender balance in the context of the new approach to nominations for the regulatory authority. They are partly based on statutory precedent in the Qualifications, Education and Training Act 1999, which sets out the requirement for an appropriate gender balance for appointments to the National Qualifications Authority of Ireland. I now, Chairman, having addressed my amendments, starting with Amendment 10, want to address opposition amendments 7, 8, 9, 12, 14, 15, 16 and 17. I am opposing these amendments on the basis that the issues they address are already being dealt with in the relevant government amendments. And I want to thank Deputy McLaughlin for acknowledging that we are addressing this important issue of ensuring that no question mark can hang over the independence of the authority when it's up and running. Practically all of the opposition amendments have been previously considered, as they were submitted pretty well verbatim by the Bar Council in their March 2012 document, Proposed Key Principled Amendments to Sections of the Legal Services Regulation Bill 2011. I am satisfied the Government's amendments to Section 8 put to rest the concerns raised on publication of the bill regarding the actual and perceived independence of the authority from government. I believe the nominating bodies chosen represent a balance between meeting the representative needs of the legal professionals, the needs of consumers of legal services and the needs of the authority. Also, Section 8 now provides that the members of the authority shall be appointed by government, but only following a resolution approving such appointment being passed by both Dáil and Seanad Éireann. The new Section 9, entitled Term of Appointment of Members of the Authority, reproduces much of Section 8, subsection 6 to subsection 15 in the published bill. The disqualification for office of a member of the authority is now covered in a discrete Section 10, and the provisions governing the removal of a member of the authority are now covered in Section 11. In reality, with regard to these sections, there are only very slight differences between the Deputy's suggestions and the amendments that I have tabled. The drafters have, in preparing the new sections on these issues with my department, given them renewed clarity of expression. I would therefore urge that the suite of government amendments in relation to the appointment and other aspects of the new regulatory authority be supported in their entirety in meeting those concerns that have also largely informed the relevant opposition amendments. And having said all of that, I do want to thank members of the opposition for the amendments they tabled and for their very constructive engagement with committee stage in the manner in which they are approaching the issues.
Okay, Deputy Collins.
Yeah, can I just, because Chair, we're discussing a batch of 10 amendments here, so we just need to, Minister, can you, you're sticking to 11. Does that include the Chair, or is the Chair in addition to that? Secondly, can you, like the initial concern was that you or your officer, your successor, when we all move on in life, as we know, would have too much influence in the appointing of members, and you have gone some way towards addressing those concerns. Can you walk us through? Can you confirm to us you don't have a veto in terms of the nominees which are being offered by the prescribed, the Bar Council, the Legal Aid Board, the King's Inns and the Law Society? Whoever those bodies offer is the person who is subject, obviously, to the criteria in terms of qualification. And can you walk us through what you're proposing yourself in relation to the other 6 members in terms of the influence or the input that the Minister of the day will have in the appointing of those people?
Well, I think the answer is the Minister of the day doesn't have an influence. The people appointed have to satisfy the relevant criteria specified in the legislation, and their appointment has to be approved by resolution of both houses. It would be open to either house to decide that some individual open to either house to reject the nominations effectively, because there has to be a resolution. So members on all sides in the House of the Oireachtas would have an opportunity, if they felt someone was nominated who was singly inappropriate and ineligible for appointment, it would be open to them to reject that. But the architecture that I've created is designed to ensure that no one can suggest that the Minister for the day is going to, in any shape or form, cherry-pick individuals, and that by doing so might put on the Legal Service Authority individuals who might, quote, do the wishes of the Minister, unquote. We're trying to ensure it was never the intention that the authority would operate in that way in any case, insofar as there was a perception that it might, because we relied substantially initially in the bill on the formal structure that applies to a variety of different other independent bodies. Insofar as it gave rise to any perceptions, I'm anxious that those perceptions be laid to rest. Of course, the nominating bodies will have to satisfy themselves of the on expertise criteria when nominating people. I would expect that they would do that. But it's not my intention that, as a minister, I would be specifically engaged in choosing individuals. The nomination for appointments, as you can see, is detailed. The procedure applicable is detailed at some length, I would hope that the way we're dealing with this would be seen to be a good faith response to the concerns that people have expressed.
Can I just ask, Chair? I think all of us have mentioned in our amendments, and have offered the option of the appointing of the lay members by the President of the High Court. Can you give us your reasons for?
I think it's appropriate that we have nominating bodies. I'd ask the question: why would the President of the High Court be given that role? This is about lay people who are going to be appointed by a series of bodies whose engagements are quite clear in the areas of expertise they have. They're not bodies who are directly part and parcel of the legal profession. They are separate from it, but that they would have sufficient expertise to be able to identify appropriate nominees based on the criteria provided. I'm not sure it's appropriate that the President of the High Court be put in a position where the President of the High Court has to make these decisions. And if the President of the High Court was to make these decisions, there's no accountability. Now, I'm not suggesting that the current President of the High Court would do anything inappropriate. Just as I know when the issue rose as to the modalities of appointments, most members didn't believe that I would do anything inappropriate in the nominating of individuals, despite some of the brouhaha and allegations made by some campaigning against the bill, who initially didn't want an independent legal service authority at all. But we can't assume that people in the future will always make the right judgments about these things. You can't have a situation where the courts are independent and the President of the High Court would nominate individuals to this body, and if they got it wrong, which isn't impossible at some future date, there'd be no accountability. The House of the Oireachtas would have absolutely no role of any description. Indeed, if they tried to play a role, you'd be accused of interfering with judicial independence. I think it's crossing the boundary that we shouldn't cross in the area of separation of powers. And I also think that the general public want an assurance that the lay people are nominated without any influence, good, bad or indifferent, from, if I could put it this way, the legal professions or the court services or the judiciary in any shape or form. I think there has to be a perception of true independence of our judicial system. And that isn't saying anything, and I hope it wouldn't be misinterpreted in any way as to be critical of any member of the judiciary or the President of the High Court. I think it's important that there's a lay nominating process that's separate from our court system and from the legal professions, and that's why we've travelled the route. But I do think in circumstances in which people are nominated and ensuring there's a mix of independence and some oversight, I think it's correct to adopt the procedure that we have with the Garda Ombudsman Commission, where the nominees must be accepted by way of Dáil resolution. Because I think that does provide an area of accountability that ensures that the nominating bodies will feel constrained in years to come to abide by the eligibility criteria.
Okay. Deputy Doctor, you want to come in?
No, I think the nominating body system is a good system and to be overseen by the Oireachtas. There appears to be 2 points of difference, Minister, key points between what you're proposing and the amendments from ourselves. The first is obviously existing Section 8, subsection 2b. That I don't understand why you insist on the chairperson having to be a lay member and why the government have to appoint that member. Could you just maybe, well, as it stands now, the government shall appoint one of the lay members of the authority to be chairperson of the authority. You haven't changed that. You're leaving that as it is. And I think the authority should be able to elect their own chairperson, and it shouldn't be just limited to a lay person. The other point I would ask you is, why you won't concede that. And then the second is, why not extend the authority to 13 members? For example, IBEC and the Irish Congress Trade Unions would be very good contributors. They're 2 organisations that are missing from your list. So just to query that.
Point, Sir Minister.
Well, let's take the number first. I would have to say to the deputies, I haven't heard, I won't say a convincing argument, I haven't heard any argument yet as to why it should be 13 rather than 11. And I appreciate the number is somewhat arbitrary, but you don't want an authority that is unnecessarily large or unwieldy. So to some extent, this is a subjective judgment. There's no ideal number. In the context of the authorities, the authority operating and looking at the balance to be struck and the nature of the representation from the legal profession, 11 appeared to be the appropriate number. Now, if there's convincing arguments as to why it should be 13, not 11, I'm happy to listen to them.